My Lord, this issue does not resolve on whether the function is judicial or administrative, because whether it is judicial or administrative, then it affects all the three parties who could act. It affects the Chief Justice, she's a petitioner, the Deputy Chief Justice is a petitioner, and if you are to look at Section 5 of the Judicial Service Act, the senior most judge, Justice Sipai, is also a petitioner. So it doesn't matter whether it's judicial or administrative. And my Lord, the Shagwa case, which I argued is pending on appeal, it could be overturned or it could stay. So, and I cannot, as an officer of the court, cite it to you as authority. But just a few weeks ago, we argued against it at the Court of Appeal. The question then turns on the issue of necessity. And my Lord, no one else would be available to act. And so the Chief Justice must then appoint, she could appoint for the 6th and recuse herself in her own file and direct that file to go to the DCJ under Article 259(3), because someone must perform the function. And yes, we agree with Mr. Nyamodi and Mr. Okacha to question of necessity, but the bench, if you are satisfied, must be appointed. Let me turn to the second of three issues I'll respond on, and that's the Shulei matter. My Lord, if you look at paragraph 79 of the Shulei case, the Supreme Court spoke about all disciplinary proceedings, and yet that's not what you're deciding today. Today you only to decide whether those arguments about what the Supreme Court said in Shulei are weighty or not. And indeed they are weighty. I turn to the final point of my reply, my Lord, and that is on what is the content of these petitions. My Lord, if you looked at Isaac Lenaola 1, IL 1, in the affidavit of Justice Isaac Lenaola, my Lord, you'll find a letter dated 27 January 2025 and received on 3rd February 2025, my Lord. I go to that letter because my learned friend Mr. Mosota said that all this is just an impression, there's nothing more there. My Lord, you find the JSC in that letter saying that the JSC has received a petition from Okach and Partners Advocates and a supporting affidavit by Raphael Tuju dated 4th June 2024 against your Lordship in respect of the above matters. The above matters are the Supreme Court decisions in question. The JSC then tells our client that the petition was tabled before the JSC on 24th January 2025. And upon deliberation by the JSC resolved that your Lordship be requested to submit a response to the petition. Now that letter is copied to my learned friend, my brother, Mr. Okach. And this is what Mr. Okach says in response to that letter. His response is Raphael Tuju1, RT1, at page 9 of the replying affidavit of Raphael Tuju, my Lord, sworn on 4th March 2024. He says on the quote, my Lord, "We have noted that your letter indicates that the complaint has been served upon the said judges, including the Honorable Justice Isaac Lenaola. We contend that this is erroneous, as our client has no complaint against the Honorable Judge. Indeed, he was not part of the bench presiding over the matter which is subject of the complaint. Please note that this petition was corrected by our client's affidavit deponed on the 16th day of May 2024. My Lord, the affidavit of 16th May 2024 is Annexure Isaac Lenaola 12. You'll find it at page 490 of the bundle. My Lord, the question whether a judge can be required to respond to a petition where they did not sit and where the complainant has conceded that the judge is a stranger to those complaints is a weighty issue. We ask you to allow the request for certification. Thank you.